This is Pat O'Connor, and the topic for this video is, should you file for binding arbitration if you're not satisfied with the value after the Appraisal Review Board hearing? Well, there are two options after the Appraisal Review Board hearing that are used most commonly: binding arbitration and a judicial appeal. Some of the advantages of a binding arbitration case are, number one, you do not need an attorney. Of course, you can file pro se in state court, but most people are not comfortable doing that. So, number one, you don't need an attorney. Number two, you're not going to need an expert witness to testify. And number three, the appraisal district can't hassle you with discovery requests. That's sending you requests for information or asking you to answer questions. So it's a much less formal process. What are the disadvantages of binding arbitration? Well, you still do have some exposure. You have to pay a fee when you file for the binding arbitration. And if this is for your homestead, the fee is $450 if the value of your homestead is $500,000 or less, or $500 if the value of your homestead is over $500,000. There are also options for commercial properties, and they vary from $500 to $1,550, with the highest amount being for commercial properties valued at $5 million, $3 to $5 million. So, the options considering binding arbitration and the advantages and disadvantages need to include unequal appraisal. If you are appealing because you think your home is unfairly valued or your commercial property is unfairly valued based on unequal appraisal, I can't encourage you to pursue binding arbitration. Our firm has handled thousands of binding arbitration cases, more than everyone else in the state combined. We've done a lot of binding arbitration, and our experience is the arbitrators will not consider or do not understand unequal appraisal evidence. Even though they're required to take training for it, my best information is the arbitrators will not consider unequal appraisal or don't understand it. So if you have an appeal based on unequal appraisal, I would not encourage you to pursue binding arbitration. If you have a clear-cut case on market value, binding arbitration is a good option. And it's less formal than a judicial appeal. It's handled fairly quickly. And with a good case that's clear-cut, you probably can resolve it before the arbitration hearing. So let's talk about what happens when you file for binding arbitration. You have a time frame to file within 60 days of the ARB order being received. Once you file your binding arbitration application, you and the appraisal district have 60 days to settle the matter. And if you settle in that time frame, the arbitrator is not paid. If you settle after 60 days, the arbitrator is paid. So let's say you have a case where it's just clear-cut. Something happened at the board and they didn't get it, or it was too big a reduction, but your house is valued at $400,000. It clearly should have been valued at $300,000, and they just left it at $400,000. Well, if you send your information in with your binding arbitration package, the appraisal district can call and settle with you during that 60-day period. You would have made a deposit of $450, and the state will keep $50 to pay the comptroller to coordinate the process. However, the other $400 would be returned to you if you settle during the 60 days after filing. If you do not settle during the 60 days after filing, it's a loser pays system. So, continuing with the same example, the house is worth $300,000. It's valued at $400,000. If the final number from the arbitrator is $350,000, you lose. If it's a split the baby value to the dollar, the property owner pays for the arbitrator's fee, the $400 in this case. If it was $1 less, if it was, say, $349,999, the appraisal district would pay the arbitrator's fee. So, in this case, with a reduction of $100,000, if you were successful, you would have tax savings of $2,600 based on a 2.6% tax fee. Even if you got to split the difference reduction of $350,000, you're still looking at tax savings of $1,300. So even if you lost and had to pay the arbitrator the $400 plus the $50 fee to the comptroller, you're saving $1,300 versus cost of $450. So arbitration, binding arbitration after an ARB hearing is worthwhile when there is a clear-cut market value case. In my opinion, binding arbitration is not a good option for unequal appraisal. In our experience, the arbitrators have not listened to or understood the information. So, binding arbitration is a great option for market value. If you file for binding arbitration on market value, try to get the case resolved within 60 days of filing so there's less risk of losing your $400 deposit for the arbitrator. Thanks for watching and good luck with your arbitrations.